All right, hi, welcome back, Attorney Steve Vondran. Welcome to another exciting video. I just have a quick video today. I thought this was pretty fun. I came across this. This is a case dealing with Jack Daniels. Let me see if I can just get right to the photo to show you here. It's a pretty funny case and deals right here. Here you go. Deals with Jack Daniels and bad Spaniels. Okay, so you can see here, this is Jack Daniels. I think most people know what this is. Old number 7. Tennessee sour mash, Jack Daniels, old number 7, making this for hundreds and who knows, I don't know, 50, 100 years, I don't know what it is. And along comes an Arizona company called VIP Products LLC. They make a dog toy. They make dog toys. This one is a parody of Jack Daniels, as you can see. Instead of old number 7, it's old number 2, like for your dog and on your Tennessee carpet. So they're trying to make fun. Hey, you know, if you drink a shot of Jack Daniels, you're going to be on the floor. If this dog plays with the toy, it's going to be poop on the floor. And he's a bad spaniel, so it's a toy. Well, Jack Daniels didn't like this too much. They have a famous trademark, of course, been around for years. And so when they started selling the products here, this is an Arizona company, Jack Daniels didn't like it. They sent a cease and desist letter, and then Bad Spaniels went on the offensive. I've talked about this in other videos. I'll put it down in the message area. They went on the offensive, filing a declaratory judgment action, asking the district court, the lower district court, to declare that they're not trademark infringing, that they're not diluting Jack Daniels' famous brand. So the case went up on appeal. Of course, Jack Daniels won at the lower court. Bad Spaniels took it up on appeal, and then Bad Spaniels got a victory there. So now Jack Daniel, not content with this doggone outcome, decided to file what we call a writ of certiorari. And again, I'm going to put a tag down in the message area. What is a writ of certiorari? That's where you ask the Supreme Court, please hear my case, please hear my case. And I have a video on it. Make sure you watch it. But it talks, there's limited times when a court is going to hear a case, usually when it's something that impacts the entire country. And I think this is great because I want to see a bright line rule. I am a big fan of parody. I'm a big fan of free speech, and I would like to see this succeed. I'd like to see this Arizona company succeed, okay? Because, I mean, is the world a worse place because you have a dog toy that's parodying this? I mean, I don't think the world's a bad place, but, you know, it's an intellectual property case. And so let's go down here real quick to the issues presented. These are the two issues that are going to be presented. The Supreme Court said, yes, we will hear it. This could be an important case. Let's lay down the rule here. Let's see what's going to go on. Issue 1, whether humorous use of another's trademark as one's own commercial product, so they're using that for their own commercial product, is subject to the Lanham Act's traditional likelihood of confusion analysis, or instead receives heightened First Amendment protection from trademark infringement claims. So, you know, the court has to decide, are you going to allow this kind of making fun of other products? I grew up when I was a kid, I had the wacky packages, and I'll put a link down to that below. It's pretty funny, but I grew up on these. I love these things, these little cards. In fact, I think I have some over there, but there are these cards that just make fun of various brands. They're not trying to injure the brand. Nobody would take it serious to think it was the brand. So I want more protection, First Amendment, more parody protection, even if it's commercial in nature as this is. So I'm pulling for the bad spaniels. Okay. Question number 2, whether a humorous use of another's marks as one own commercial product is deemed non-commercial under the law of the Lanham Act here, thus barring the case for dilution by tarnishment. So we'll see. Those are the two questions. Now, interestingly, let me go down a little here. So Jack Daniels presented some other examples here, which I think they're trying to make more of a safety type of argument. Oh my gosh, if you do these funny products and they're spoof products or parody products, somebody could still get hurt. You know, the dogs could take Jack Daniels and maybe get hurt. I mean, come on. I don't think that's going to happen. I don't think the dogs are going to die and end up in the veterinarian's office. But here's a couple that they showed. Double Stuff Stonio, making fun, of course, of the Nestle famous Oreo cookies. And so Nabisco obviously didn't like that. You can see here double stuffed Stonio. Down here also one. Ferrera Candy Company sued a company selling marijuana-infused candy. Now, I get it. Like, you have to be really careful about that. And I could see the problem here. That's a safety concern. And, everything weighs in on these final analysis. But so you have some examples that they were advancing as to why this should not be allowed. So the Supreme Court took it up in December, late December. Probably going to hear it sometime early this year, so I will keep you guys posted. But I thought that was a pretty interesting case. Again, I'm pulling for the Spaniels. I want parody. I want free speech. I don't think the world is worse off. I don't think Jack Daniels is worse off. I don't think there's a likelihood of consumer confusion here. I mean, the people buying whiskey for their family or people buying bad Spaniel Tennessee carpet. I don't see any consumer confusion. So I'd like to see it stand. We'll see what the court says. They may look at things differently. And there is a lot of case law talking about parody and when it's good and when it's not. So, but that's it. Quick overview. I will keep you guys posted. Make sure you subscribe so you can find out what happens. You want to know what happens so you can tell your friends, right? All right. Thanks for listening, you guys. This is general legal information only, not legal advice. Have a great Saturday. I got to run. We will see you guys next week. Bye now.